Get started. So our presentation today is called Pathways to Protection, Navigating U.S. Immigration Law for Victims and Survivors of Crime. This is a really general presentation. We're going over the law in these very niche areas, so just a few areas of immigration law. We will not be answering any questions related to specific case questions. So if you have a question about a specific case, your own case, we won't be answering those questions today. This is being recorded. And so we really encourage you, if you have questions about a specific case, a specific set of facts, please definitely do go to an immigration attorney, Department of Justice representative to get those questions answered. But today is not legal advice, just a general overview of some areas of immigration law. Okay. Okay, so first we're going to go over how is U.S. immigration law even created? Where do we derive immigration laws from? And so there's a few different places. The first one is the United States Constitution. We get some of our laws that we have to abide by from the Constitution. We also get some of our rules from the Immigration and Nationality Act, which is sometimes known as INA, the abbreviation of the title of it. We get some from federal regulations. Some of our laws come that way. We also have executive orders from the president that get transferred into immigration law. And then we also have agency memorandums. So this could come from agents. This could come from agencies like USCIS, issuing their own set of rules that we must abide by. And so there's a few different areas that bring us immigration laws, but this is mostly where we derive those from. Immigration law is all federal, so the states don't usually get to create their own immigration laws. What agencies are involved? So historically, the Immigration and Naturalization Service, which is known as INS, is involved. There's also the Executive Office for Immigration Review, which is known as EOIR. That's like courts, okay? Then we have the Board of Immigration Appeals, which are cases that have been decided and then are under appellate review. So there's been some issue when they were deciding that case that is now being appealed and decided there. These are all part of the U.S. Department of Justice. We also have the U.S. Department of State, the U.S. Department of Labor, the U.S. Department of Health and Human Services. Historically, before 9/11, immigration law was all under the Immigration and Naturalization Service. But after 9/11, we created the U.S. Department of Homeland Security, and that's where we get USCIS, which stands for United States Citizenship and Immigration Service. We also get ICE, and we get Border Patrol, all from the Department of Homeland Security. Okay. I should have said this before we started our presentation, but if you do have questions, we are willing to answer these questions if you put them in the chat. That's probably the easiest way to get to them. We'll also have a little bit of time at the end carved out for you to ask any of the questions that you have. All right, Carmen, I will turn it over to you.
Thank you, McKenna. As most of us know, that the Violence Against Women Act was enacted in 1994, and it included provisions for immigration protection for survivors of domestic violence and other crimes. Under VAWA, the U visa and the T visa were included. They were created as part of the Victims of Trafficking and Violence Protection Act of 2000. Specifically, it was established by the Battered Immigrant Women Protection Act of 2000, and they were a big part in the larger Victim of Trafficking and Violence Protection Act. The U visa and the U visa program officially came into effect in October of 2000 when the law passed, and the regulations for implementing the U visa were not finalized until 2007. Which is when USCIS started accepting applications for the U visa. The T visa, it was also created in 2000, and the regulations for its implementation were not finalized until several years later. So the Department of Homeland Security published the first regulations for the T visa in January of 2002. The purpose of the U visa is to provide immigration protection to victims of certain crimes that have suffered substantial mental or physical abuse and are willing to assist law enforcement and government officials in the investigation or prosecution of the crime. And the purpose of the T visa is also to protect victims of severe forms of human trafficking and allow them to remain in the United States to assist in the investigation or prosecution of the human trafficking. Can we go to the next slide? Okay. For the U visa, the eligibility, and I want to say that we recognize that some people call themselves victims and survivors, but for the purpose of talking about immigration law, we're gonna say victims, okay? The victim of the qualifying criminal activity have to have suffered substantial or mental abuse, like I mentioned. They have to have information about the crime. The crime has to be reported. They have to be helpful, are willing to be helpful, or they're likely to be helpful to law enforcement, to the district attorney's office, to the agency that is prosecuting or investigating the crime. And the crime had to happen here in the United States. The applicant for the U visa also has to be admissible to the United States. These are some of the qualifying crimes for the U visa. The ones that are bolded in black, you can see those are the ones that we see the most in our office. Also at the bottom, any solicitation, attempt, or conspiracy of the above crimes, it means that any crime that could be framed as a potential felonious assault or as a potential sexual assault, it can be argued as a qualifying crime for the U visa. The person has to have information and they're willing to help. They need to provide the information to law enforcement, and a conviction is not required. If there was an attempted murder and the perpetrators left the scene, if the person reported the crime and was able to help with the investigation, that is enough. There must at least be an investigation, like I said. And there also has to be a certification of the helpfulness and information from law enforcement. This certification, it's an immigration form. It's the Supplement B I-918, and it has to be signed by a certifying agency. It could either be law enforcement, police department, it could be the district attorney's office, and in some situations, it can be the Department of Human Services if they're investigating either domestic violence or a sexual assault. The certification can be revoked by the issuing agency if the victim does not cooperate anymore in the investigation. It does not guarantee the approval of the U visa. This is only the first requirement for an applicant to apply for the U visa. And it's only valid for 6 months. Once we have the certification signed, we have to get the U visa application together before the certification expires. The U visa is a temporary visa. It does not mean that the person has residency or citizenship. It's also called a U visa, but it doesn't mean that the person is able to travel outside the United States. For the purpose of the U visa, the abuser does not have to have any immigration status. And if the person is in removal proceedings, this can be a tool they can use for protection against deportation. Some criminal convictions can make the person inadmissible. And if they are inadmissible, they have to apply for a waiver. Under the U visa program, the I-192 waiver of inadmissibilities is the most forgiving in immigration law there is. Entry without inspection or unlawful presence are usually waived, but not all grounds are waived because this waiver is discretionary. If the U visa is approved, you get a work permit and you get your status for 4 years. After 3 years of continuous physical presence, you are able to apply for legal permanent status or residency. Some qualifying relatives are eligible to apply under the U visa as derivatives. Let's say that I am a child victim of sexual assault and I'm applying for the U visa, so I can apply for the U visa. My parents are able to apply under the U visa if I'm under 21, and also any unmarried siblings I would have if they're under the age of 18. If the principal victim is over 21, they can have their spouse apply with them and any children under 21. It's also such a great tool for family reunification, because if, let's say that the crime happened here, if I was if I'm a survivor of domestic violence and I'm applying for a U visa, but when I left my home country, I left 3 kids there. If my kids in my home country are still under the age of 21 and unmarried, I'm able to apply for them as derivatives of my U visa application. Once my U visa gets approved, their U visa will get approved, and then they would have to do consular processing. But it's such a great way of uniting families after being separated. The U visas are limited to 10,000 per year. That's why the wait list is growing and growing and growing. If the cap is reached, what USCIS has been doing, they're placing people on a wait list and giving them deferred action. Deferred action means that it's the lowest priority of deportation that a person can be put on. And when they have deferred action, they're able to get an authorization for work, which lasts 4 years. Attorney representation is not required for the U visa, but it's always a good idea to be able to have a good consultation to see if the person is able to qualify, but also to talk about any potential inadmissibilities that they can encounter.
Thank you, Carmen. All right. So the U visa is one option that folks have if they are survivors of those certain kinds of crime and have helped law enforcement. Another potential option for folks is a T visa, and the T here stands for trafficking. So this slide, we're going to discuss what makes you eligible for a T visa. And so first of all, you have to establish that you have been a victim of a severe form of trafficking, and that is either a sex trafficking or labor trafficking. As Carmen said, there's various different terms that people identify with and use, and for the purpose of this presentation today, we're going to use the language that USCIS uses, which is victim. A person who is applying for a T visa must be present in the United States on account of that trafficking. So if you were trafficked into the United States for labor trafficking, that could count. Or say you came to the United States, but you stayed here because of trafficking, that could also make you eligible for this sort of visa. So something to consider. The person who is applying must also have complied with reasonable requests for assistance in the investigation or prosecution of that trafficking. So this is kind of twofold here. First, a person who is pursuing a T visa must have reported the trafficking. You can do that with an attorney, with a victim advocate's help. On your own, you can do that, but you must report it to law enforcement. And then the second piece is that you must comply with the law enforcement's requests for assistance in whatever their investigation looks like. Okay. Finally, an applicant must show that they would suffer substantial harm if they were removed from the United States. Okay, this is all part of the application process, but these are the main things that you must hit on. All right, so the benefits of a T visa. There's potential for employment authorization. A T visa, much like a U visa, can be a pathway to citizenship if everything gets approved along the way. It allows you to remain in the United States. If you have a T visa, that's good for 3 years. After the 3 years, you can potentially apply to become a lawful permanent resident. After being a lawful permanent resident for 5 years, you could potentially apply to become a citizen. As Carmen said, with the U visa, the names are confusing, but they are not visas to travel. If you have a T visa, you must remain in the United States. But there's also, with the T visa, an ability to file a waiver for any sort of immigration inadmissibility. So again, if you have come into the United States without permission, that's something that could be waived. One of the biggest things for T visa is that potentially a record of prostitution can be waived in your background if you are a victim of sex trafficking, and that is a piece of your criminal record or just your personal history. Though USCIS, that's against the law in the United States, it could be waived through the T visa process and that waiver process. All right. The next form of relief is what's called a VAWA self-petition. VAWA stands for Violence Against Women Act. The name can be misleading because it's not only for women, it can be for anybody. But this self-petition is a way for folks to obtain lawful permanent residence, work authorization, and receive protection from deportation without an abusive spouse's sponsorship. And if they can show that they were subjected to battery or extreme cruelty by a U.S. citizen or a lawful permanent resident. There are a few different avenues that you can take in terms of if you have a spouse who is a lawful permanent resident or citizen, and they were abusive to you, you can apply for VAWA. Also, if you have a parent who is a lawful U.S. citizen or a resident, or if you are a child, if your child is a lawful permanent resident or a citizen and they're abusive to an undocumented parent, person without documentation, they could also potentially apply for a VAWA, the benefits of a VAWA petition.
McKenna,
Yes.
we have a question from Jane. She's saying, sorry, what do you mean in U visa?
I'm sorry, I'm not certain I understand the question.
I just replied to that. It's the U in the U visa, it just means unauthorized. It's for an authorized immigrant, non-immigrant.
Thank you, Carmen.
Thank you.
Perfect. And so with that, we'll explain VAWA a little bit more. So before VAWA was enacted, immigration law historically gave spouses and parents who were the U.S. citizens or lawful permanent residents control over their family members' immigration status. So if a spouse wanted to apply to become a lawful permanent resident, they needed to, under all circumstances, needed their spouse to sign off on it, accompany them to interviews, that sort of thing. Let's see, there was a lot of dependence on U.S. citizen spouses or parents over that application process. And that exerted a lot of power and control for folks who were dealing with intimate partner violence or abusive parents, abusive children. There's a lot of control over those folks and their status with somebody who did not have their best interests at heart, right? And so seeing that there is an issue, the US government enacted VAWA. And so VAWA, again, standing for Violence Against Women Act, it's a statute. The form that we use is the I-360. All immigration forms have a letter followed by various different numbers as their identifier, their form identifier. And so the VAWA form is an I-360. And it can be used for a plethora of different applications. And we're going to focus today on being an abused spouse of a lawful permanent resident or a U.S. citizen. Okay, so eligibility for this process is that you must be a victim of domestic abuse perpetrated by a U.S. citizen or a lawful permanent resident spouse. Okay, you must have evidence that supports that there is abuse, and that's classified as battery or extreme cruelty. So understanding that abuse isn't always physical, it can be emotional, mental, financial, but you have to have some sort of documentation to prove that abuse. So if there are pictures, if you could write a statement, if you have friends or family that can attest to what you are living with, bank statements, text messages, those sorts of things can be helpful in building that case. You also need to prove that you had a bona fide or legal marriage. That means that if you had a marriage certificate, that counts. But in the state of Colorado, we also recognize common law marriage, which means that both people in the partnership held themselves out to be partners, to be spouses, and you lived your lives in such a way. So if you have tax documents that show that you two were married, if you have family members who are willing to say, yes, that was this person's husband, though they don't have a marriage certificate. Okay. You also have to show that that an applicant lived with their abusive spouse for at least a day. You have to show that you live together. So whether that's a lease, utility bills that are at the same address, school paperwork for kids, anything like that showing that you all live together. You must have lived together at some point in time. And finally, you need proof of the abuser's status as either a lawful permanent resident or a U.S. citizen. That can come in the form of their residence card, their birth certificate, U.S. passport, social security card, those sorts of things. An applicant must also show that they're a person of good moral character. This is very vague and can be a little bit hard to pinpoint, but essentially you have to show that you're a person who's trying to live their life as best they can, following the rules of the United States, that sort of thing. And so you can submit lack of arrest records, Colorado Bureau of Investigation records, just any sort of clean history that you have, clean DMV history, that sort of thing, to try to go towards proving that you're a person of good moral character. And this isn't a judgment I'm making. It's not a judgment that Carmen is making. This is a USCIS rule that we must follow. And they're the ones who get to determine what is or what is not good moral character. The U visa application process requires that there is a criminal case investigation. If you are married to a U.S. citizen or a lawful permanent resident who is abusive, a criminal case is not required. So if I have been with my partner for 20 years, we were married, and there's a long history of abuse, but I never reported it for whatever reason, that's okay. I am still eligible to apply for the VAWA petition as long as I'm able to prove in some other way that I was subject to this abuse or extreme cruelty, battery or extreme cruelty, excuse me. If there is a criminal case that was opened regarding, domestic violence or assault, something like that, that can definitely be used as evidence of that abuse, but it's just not required. Okay. And then finally, the abuser, the abusive spouse's immigration status is absolutely relevant to being eligible for this. If your spouse is not a resident and not a U.S. citizen, then you do not qualify for VAWA. Okay. All right. So what are the benefits of VAWA? So if you are married to a U.S. citizen, you can file what we call a one-step application. And that means that you can submit the VAWA paperwork itself. You can also submit the application to become a permanent resident and a work permit application all at the same time. So all in one step. If you are married to a lawful permanent resident, the application process is slightly different, and you're only going to be able to file the VAWA application first. And then if that's approved, then you're eligible to apply for the work permit and you'll have to wait until a visa becomes available to apply for residency. That depends on where you're from, that sort of thing. So that one is a little bit more convoluted. I can't fit it into one slide. All VAWA applications do require an interview with a U.S. immigration officer. At that interview, they'll go over the applications that the applicant submitted, the evidence that they submitted, and ask them questions about their marriage, about their relationship, and any of the other information that is required on those forms. But an interview is required. You'll also have to undergo a medical exam with a qualified civil surgeon who's registered with USCIS. And so that would be making sure that you're up to date on required vaccines, get tested for tuberculosis, a few other conditions, and that's required of anybody who is trying to become a resident of the United States. So you will have to do those things. They can get a little bit pricey, so something to pay attention to if you have somebody who is wanting to apply for this. A lot of the times Medicaid does not cover the medical exams, and they can be a couple $100s, like $300, $400, $500. So something to be considerate of if you have folks who are trying to apply. If your VAWA application is approved, and then if your residency application is approved, you can be a permanent resident. It's good for 10 years. And with resident status, you can work, you can travel outside of the United States. And ultimately, if you want to just continue to renew residency status, you can do that. Or after 3 years of being married, having been married to a U.S. citizen or a lawful permanent resident, you could apply to become a citizen. Okay. Let's see. Let's finish up. Okay. This is quickly for eligibility requirements for a parent who has survived abuse at the hands of their U.S. citizen children. Okay. So a parent of a U.S. citizen who is at least 21 years, I'm sorry, this counts as a qualifying parent and child relationship. If you're a parent of a U.S. citizen who is at least 21 years old when you apply for your VAWA, if you're a parent of a U.S. citizen who lost or renounced their citizenship status because of an incident related to domestic violence, or if you're a parent of a U.S. citizen who is at least 21 years old and who has passed away within 2 years of filing. So, for example, if I didn't have lawful status in this country, my son is a U.S. citizen, he was abusive, and he passed away on June 1st of 2024, then I would have until June 1st of 2026 to get my VAWA application submitted to the United States government based on the abuse from my son. Okay. Parents will also have to show that they suffered battery or extreme cruelty at the hands of their U.S. citizen child. The parent must have also resided with that child. So, if you are a dad who has never lived with your children are abusive nonetheless, you don't have that qualifying cohabitation piece. Okay, so you must have lived together. And again, as with every application that you submit to the U.S. government, you are going to have to prove that you're a person of good moral character. We could have like a class, multiple semesters on what it means to have good moral character. But again, what you were looking for is a relatively clean criminal record. If there are charges of like terrorism or weapons charges, theft, those sorts of things, gang involvement, those sorts of things get a little bit hairy. If you've had a speeding ticket in your past, it's not great, but that's probably not going to automatically make you ineligible based on good moral character. So whatever you can submit to show that you've been abiding by the laws, that you don't have any of these theft or gang-related violent criminal charges, no fraud charges, that's what we're getting after. Finally, here are some references that we used to create our presentation. We will be sending this PowerPoint out after we are done. And so if you want to click on these links to find out more information about any of the topics that we covered, that is just fine. They are here for you to use. And then this is us. We are Justice and Mercy Legal Aid Center. Like I said, we're in Denver. That is our phone number and our website. If you would like to get in touch with us, or you just want to find out more about JAMLAC, you are obviously welcome to use those links, use that information to find out more information. And now I think we have a good amount of time for any questions that folks have. Just a reminder that we won't be answering specific case-related questions, but we will absolutely do our best to answer more general questions that folks have about anything that we've covered today.
Thank you, McKenna. Thank you, Carmen. So yes, please hop off of mute and ask your questions.
I do have a question about the U
Introduce
visa.
yourself.
Oh, yes, my
I'm
name is
sorry.
Christina. And I work for advocates. My title is Bilingual Confidential Youth Advocate. And my question is, so you said that after applying for U visa, do you have to apply for the deferred action? So that way you're on the wait list to get a permit, is that correct?
You don't have to apply for deferred action because the U visa, it's taking a long time since they only are able to issue 10,000 U visas per fiscal year. Once they review your application and they see that you have the evidence necessary for the U visa, they send you a letter with deferred action. The letter, if you're able to see it, I mean, it literally says you basically have met all the requirements. If we had a U visa available, we would give it to you, but because we have reached our cap, then we're placing you in deferred action, and then you're able to get a work permit.
Oh, okay. So they're basically going to let you know if you're gonna be on the wait list under deferred action.
Yes,
Oh, okay. Thank you. Appreciate it.
thank you.
Hi, this is Laura. I am with the Blue Bench. As a follow-up question to that, about how long after, say, you were to receive that letter that you're on deferred action, would you be able to get the work permit? Like, is it pretty soon after? Is it several months?
That's a tough one to answer. We have seen both cases. I'm sorry that that's not super streamlined, but we've seen both. So sometimes, it's a matter of weeks maybe, or you could get it simultaneously, like this letter and the work authorization kind of come in the same week, which is wonderful. But sometimes you're waiting a few months. I could say even in some cases, there's so many people applying. I mean, it could get close to a year. We've just seen a lot of delays and that sort of thing. USCIS is going through a record number of applications this year. And so it's hard to predict. I'm sorry, Laura, that I can't give you much information.
No, thank you. That was super helpful.
Another thing to add, that I would add to McKenna's answer is that what we have seen is that the main applicant of the application is the one receiving the work permit. And then once that is issued, then they'll give it to the family members, the derivatives. But what we have seen is just mostly the main applicant getting their work permit or deferred action. And then it's taking a while for the family members to get their work permits. It's just a trend that we're seeing.
Is it hot out there? Yeah. Elaine, do you have a question?
No, I'm sorry.
Do we have any more questions for McKenna or Carmen?
Sorry, this is Laura again. Not necessarily about the presentation. I hopped on a little late, so I might have missed it. But how does one get connected to the services of JAMLAC? If we have a client who we identify may qualify to get a U visa, how do we get them connected to you all? Are there any like qualifications that they have to meet? Anything like that?
I found out one day he's only 2 years older than me.
Yeah, thank you, Laura. So like I said, we are in Denver, and the immigration department is able to, we have some flexibility in terms of serving people who live outside of the Denver metro area, but for the most part, we can't serve anybody outside of Colorado, so that's one of them. And then we do have income requirements. If you're applying for a U visa, you're going to be a survivor of a crime, so mostly we serve, majority of our clients are survivors of some sort of crime. Okay, and then in terms of our income eligibility, you have to be at around 150% or less of the federal poverty guidelines. We have a tad bit of flexibility there, but not much. So if they're well over 150%, unfortunately, JAMLAC probably isn't the best resource for them. But if a family is at or below that 150% of the federal guidelines, we'd be happy to talk with them. And I think the best way to contact us is to the phone number. I can put the phone number in the chat again, but to give us a call. And then I think Carmen and I both are willing to share our emails as well. And so you can also send us an email and kind of, if you could tell us, you know, where the person is living, and then with their permission, maybe a short summary of what's going on, that would be helpful, so that we can kind of just get an idea of whether or not they qualify, and then we can set them up with an intake. And that's talking with our victim advocate, getting more information out of that person. And then from there, if we're able to have a consultation with them, they would speak with an attorney or a Department of Justice representative. I'm sorry, Department of Justice representative, accredited representative, to go from there.
Perfect. Thank you so much.
Absolutely. Carmen, do you want to type your email?
I type my email and I see a question from Karen. I can read it, McKenna, and I can answer because I actually have some clients in that same situation. And then if you have other stories as well, McKenna, but Karen's question is there a specific time frame that the abuse needs to occur in order to be eligible? Let's say the abuse happened 10 years ago. Karen, I can share with you that it really depends on the certifying official, the agency that is going to, where you're going to be requesting your certification from. I currently have, I would say, 3 clients that the case happened like 10 years ago, and I was able to get 2 of those certifications signed. I called the law enforcement agency myself directly, and I was lucky enough to speak to the certifying official. He was a lieutenant and he was very nice, and I explained that my client, you know, she suffered from domestic violence. She was a survivor of extreme abuse, and there was a lot of things happening, and he was fine. He said, send me the certification. He was able to find the police, with the police report number, he was able to find her case, and he said, yes, send it to me and I'll review it, and you know, I'll go ahead and sign it. So I was lucky enough to be able to talk to the official. At another case that we had here at JAMLAC, it was a sexual assault case on a minor, and she came to us when she was already an adult. So she was able to apply, and her mother, who was very involved in the investigation, she was very helpful. She was always there with the daughter. She didn't know that she could apply as a secondary victim. So we were able to request a certification for the mother. When I request her certification, I included the daughter's signed certification. And I said she was a secondary victim. She was involved in all the investigation. He can please sign this. And I was able to get that signed. So I would say it really depends on the certifying agency, and sometimes they have specific guidelines. I know there's some folks from the district attorney's office, if you can jump in and help us with that, but there's some specific guidelines as far as like how far the cases are safe, or if they have anything that they have to close out and they might not be able to sign the certifications.
I think, Carmen, that was great. So to answer your question, it's that maybe there isn't a timeline. I think it's worth talking to an attorney or a DOJ accredited representative just to see what your options might be if somebody is in a situation like that. In terms of like, I don't know if it was just related to a U visa, but for a VAWA, you could also have domestic violence maybe happened years and years ago in your marriage. You could still pursue a VAWA based off of that. So there's some maybe flexibility, maybe isn't the right word, but I think it's worth speaking with somebody about if this crime happened a while back. I think as it relates to the U visa, just to add a little bit, getting the certification signed is one step in the process. And so just because a certification is signed, that also isn't a guarantee that a U visa will be ultimately approved, right? So obviously you need that certification in order to move forward with the process, but it's also not a guarantee that USCIS will also accept it. And that could be for any reason, but just throwing that out there, the U visa certification is required to be able to apply. But just because you have it doesn't also mean that your U visa is like kind of rubber stamped. That's not how it goes. So something just to consider.
Thank you. Do we have any more questions before we put the survey in the chat? All right. Kathy, will you please share the survey in the chat, the link? Thank you. Everyone, please share your feedback with us and the presenters today on this lovely Tuesday morning. Let us know how we did. Thank you for being here. Thank you. You as well. Thank you for coming. Please be on a lookout for the PowerPoint and recording on the CICASA YouTube page. That's where you will find all of the awesome webinars that we've had in the past. Please reach out to Kathy, Agatha, or myself if you have any questions. Doesn't seem like we have any more questions. So McKenna, Carmen, thank you so much for taking time to be with us today and answering all these questions and giving us the information that was much needed for the survivors that we serve on a daily.
Thank you for having us. We really, really appreciate it. And thank you all for all the work that you do.
Thank you. Thank you, everyone.
Marisela says, thank you, very informative and a great resource, of course. I think that when we talk to members, one of the resources that we lack the most, and especially in rural areas, is family law or immigration law or any kind of law. So having this resource is huge. I guess I do have one question. Are you available for like Zoom calls instead of in person? I don't know if you said that before.
So that's a great question. We definitely have Zoom capability most of the time. If folks are not able to come to the office, we try to do consultations over the phone. If somebody really is preferring Zoom and has access to Zoom via their phone or computer, I think we could absolutely try to make that work. I don't think we've utilized it too much. We've mostly had phone calls, but we're not opposed to it. And one thing, I'm so sorry to jump into this, but I totally forgot in the VAWA presentation that I really want to make sure is clear. If you are applying for VAWA based off of intimate partner violence at the hands of a spouse that's a lawful permanent resident or a U.S. citizen, a divorce is not necessarily required. Additionally, if you wanted to get divorced from that person, you absolutely can. It is just really important to make sure that you apply for your VAWA application within 2 years after a divorce is finalized. So the day that a judge says that you are now divorced and you have a divorce decree, you need to submit your VAWA within 2 years of that date. So if I got divorced on June 1st of 2024, I would have until June 1st of 2026 to apply for VAWA. Just wanting to put that out there.
I used to get that question a lot.
Carmen and McKenna, while you're on here, Itzel and I just got an email from Angeles Mendez, who is with the Western Slope migrant farm workers group that we've been doing some work with, and it's talking about the benefit recovery fund that provides a form of unemployment insurance for undocumented people with taxable income in Colorado. Have you heard of that? Sounds like it's relatively new.
Yes, I have, and Carmen, you can totally jump in if you have more information. I've heard of this. It is
Sounds kind of exciting.
Absolutely. It is not an area of law that I myself know about. Again, Carmen, correct me. I don't want to speak for you if you, okay. So not an area of law. We don't do a lot of employment based things, whether that's getting somebody a visa for work.
Experts in everything.
Yeah, exactly. So these things that's really important. By all means, if we come across any resources, we can share them with you. But it sounds like this person might be a little bit more informed than we are about what exactly that entails. Just because of the nature of our work, we don't know too much about that.
Yeah, sure. We just as the webinar was going on, we got this email from them, and it just sounded very exciting. And it's the Benefit Recovery Fund through the state of Colorado and the Office of New Americans, which sounds very exciting.
That is exciting. Thank you, Kathy, for sharing. I have not looked at my emails yet. So, does anybody have any more questions? Thank you, Alejandro. You are amazing. Thank you, thank you. We have a couple folks still sticking around.